Hello, and welcome to another episode of Jurors in Disguise, the podcast that exposes liars. My name is MaryRose Peterson, and I own Covert Ops Jury Investigations. What do we do? I'm glad you asked. We are hired by convicted persons to find the biased jurors who lied during the voir dire jury selection and denied them a fair trial. In the last episode, my guest was Martin's appellate attorney, Steve Gosney. In this episode, I'm going to talk about what we did after the direct appeal was denied. I titled this show A Rose by Any Other Name, and that'll make more sense later. I'm going to outline how we uncovered that our jury foreperson lied to nearly every question asked of her during the voir dire, which, as I've explained before, is a fancy French term for to speak the truth. And that's what they call jury selections. I want to start this, too, by dedicating this show to Michael. My partner in crime solving was the phrase that we used often. Michael was someone that came into my life shortly after Martin had been falsely convicted, and I was trying to figure out what to do, getting to the end of the direct appeal and not really sure what the next step was going to be. And I met Michael. I should say God brought Michael into my life. I'm not going to use last names. So the investigation portion of our case began in April 2015 when I watched the movie Runaway Jury. I sat there during the movie thinking, I wonder if one of our jurors lied to get on the jury. And that concept was really foreign to me because, as I've said before, I served on a jury and I tried to get off of the jury. I didn't want to be there. I never wanted to be there. So I couldn't understand why someone would lie to get on a jury. And then I watched the end of the movie and I realized, okay, this guy had an agenda and it was honorable. But it did get me thinking about our jury because the verdict, based on even what was said during trial, made no sense. And I tell people all the time, if you filter the guilty verdict through what you know about the case and what was said at trial, and you walk away going, that makes no sense. It should have been a mistrial or a not guilty or a hung jury. It should never have been a guilty verdict. But if you filter a guilty verdict through the fact that possibly one of those people in that jury room was biased against you or in favor of the state, then it makes perfect sense. In fact, it's the only explanation that makes any sense, is that you had a biased juror on your jury. So I watched the movie, like I said, and I started thinking, and I didn't really know anything about investigating back then. Neither did Michael. But I said, well, all I know to do is look on Facebook. And I will tell you, even today, all these years later, that's not a bad place to start. But I will say that you have to be very careful not to use your own personal Facebook page while you're searching. So searched on Facebook, and I was looking for the people that I remembered on the jury. I was specifically looking for our foreperson. I started with her. I remember she had given that big speech and then she turned on us. So I thought, well, let me start with her. And even today, our investigations always begin with the foreperson, even though I would say only about half of our cases are solved by finding that the foreperson was biased. But we started looking for this woman who was calling herself at our trial Rose Elizabeth Stokes. So as I searched Facebook, I was looking for someone with that name who also fit the description of the person that I remembered at trial, which, again, context, this was 3 years after Martin's conviction. I couldn't find a Rose Elizabeth Stokes on Facebook, but I did find somebody with the last name Stokes. And when I pulled up her Facebook page, I said, that's got to be either her daughter or her sister or someone related, because it looked just like the Rose that I remembered from our jury selection. So I started looking through her photos. Sure enough, there was a photo of her and Rose and a woman in a wheelchair. Found out later that this was Rose's daughter's Facebook page, and her mother was the one in the wheelchair. As I continued to look through the photos of Rose's daughter's Facebook page, I found one that left me speechless. It was a picture of the Hunger Games ad, And as I looked on that, to the right, there was a reaction by someone that was clearly a friend of the Foreperson's daughter. That person was Martin's accuser stepdaughter. They were Facebook friends. Now, this was predated before trial. They were talking and friends before Martin's trial and after. Did not go to the same high school. They lived in a county that had over 170,000 people. And I thought, how do these two girls know each other? Never did have that question answered, but I thought that was significant. So we continued to research the jury foreperson, Rose. And around that same time, our direct appeal that Steve Gosney had been working on was denied. So we continued to search. The next few months, we uncovered several key things about Rose that I thought were very important. And ultimately, we actually included these in a motion that we wrote. But one of the things that we found pretty early on into the investigation was that Rose had strong ties to the Department of Corrections. Her husband was involved in law enforcement and the Department of Corrections. Her mother was prior law enforcement and worked for the Department of Children and Families. Rose's stepfather was retired military and retired law enforcement with ties to the Department of Children and Families. Rose's daughter, again, friends with Martin's daughter, accuser. Rose had claimed to be a victim of domestic violence in an injunction that she took out against a former husband. She was herself arrested and charged with multiple counts of check fraud and placed on probation. This was all prior to Martin's trial. And then another thing that was very concerning is that Rose and her family have had a long-standing history of an intense level of compassion for neglected, abandoned, and abused children, as evidenced by her family who fostered and adopted over 600 children. She should never have been on Martin's jury based on that, but none of that was disclosed during the voir dire. During the voir dire, Judge Daniel B. Merritt Jr. asked the prospective jurors, quote, "Do any of you have any close friends, family, or relatives who are engaged in any aspect of law enforcement?" 4 prospective jurors spoke up. They were all struck. Rose said nothing. We also found that on Rose's LinkedIn page, she endorsed members of the Department of Corrections. Not only her husband, but a former employee of the Department of Corrections for Florida. Rose's then husband claimed on one of his Facebook profiles to be a transitions facilitator for the DOC. He was endorsed on that profile by his wife, Rose, and by another current DOC employee and an employee of a foster care agency. In fact, he also endorsed a former DOC employee. When we discovered Rose's then husband's LinkedIn page, we discovered that he was a transitions facilitator for the Florida Department of Corrections. He was endorsed on his profile by his wife, Rose, by a current DOC employee, and by an employee of a local foster care agency. We found that Rose's mother was a police officer from 1980 to 1993. From 1987 to 1993, she was employed with the Brooksville Police Department in Florida. She was also a Brooksville Department of Children and Families Child Protective Team investigator in 2004 and 2005, and worked for various children's advocacy and foster care groups since 2000. Martin's trial, again, was in 2012, so this was all prior to Martin's trial, and yet Rose said nothing during the voir dire. Like I said, her stepfather was retired from the military, and then he went into law enforcement. Of particular interest to us was that he was a deputy with the Pasco County Sheriff's Office from December of 1999 to February of 2013, and was a child protection investigator certified by DCF. Lastly, we discovered that Rose's stepfather had retired from the military and went into law enforcement. Of particular interest to us was that he had been a deputy with the Pasco County Sheriff's Office in the county right adjacent to Hernando County, Florida, where Martin was tried and convicted. He was actually with them still at the time of Martin's trial. He was also a certified child protection investigator and worked for the Bloomfield Police Department in Connecticut, where they were from. Another question that Judge Merritt asked the prospective jurors was, do any of you know anyone associated with the case? Now, Rose may not have even known that her daughter was Facebook friends with Martin's daughter accuser, and she may not have remembered that Judge Daniel B. Merritt Sr., Judge Merritt's father, was actually one of her ex-husband's divorce attorney back when he was an attorney. She may not have remembered those things, though, so I'll give her that. When the court asked the prospective jurors, have any of you ever been the victim of a crime, Rose again remained silent. However, according to official documents at the Hernando County Clerk of Court's office, under the name Colette Ann Voyer, which was her real, true name, Rose filed a temporary injunction for protection against domestic violence, repeat violence against a former husband. There was also a motion for restraining order asking for temporary custody of their son. When the court asked the prospective jurors, have any of you or a family member ever been charged with a crime? That's when Rose said, about 20 years ago, I wrote a check that didn't clear. It was a misdemeanor. Again, according to official documents on file at the Hernando County Clerk of Court's office, Rose, using the name Colette A. Voyer, was arrested, charged with multiple counts of check fraud in 1994 and 95, and placed on probation. One of the things that we do now, we do this at the beginning of every investigation, is we identify all of the immediate and extended family members of the jurors before we ever start running background checks and looking in clerks of court records and all of the things that we do now, all of the processes. But back then, we didn't know about background checks and some of the things that we are able to utilize now. But we did, because of Michael, we were able to identify Rose's immediate and extended family. That's how we found her stepbrother. And we also found a sister of hers who had been charged with a DUI in 1999, was charged with misdemeanor assault and criminal mischief, felony assault and criminal mischief. And she also filed a domestic violence injunction against a then boyfriend and later requested an order for child support. Again, these are just some of the things that we found that were not answered truthfully by Rose during the voir dire. Now, I realized she could say, well, I had no idea about any of that, even though they were living in close proximity. Okay, again, I'll give her that. One of the last questions that Judge Merritt asked the prospective jurors was, do any of you have any personal interest in the outcome of this case? Do any of you have an opinion or state of mind regarding the charges against the defendant which would in any way prevent you from acting impartially? Crickets, crickets. Rose said nothing, despite the fact that, as I mentioned, during her lifetime, her grandparents had fostered over 600 children and even adopted several as their own. So these were some of the things that we were finding or had found when we began the investigation. Those were just some initial things. So in June of 2015, after we had just worked a few weeks on this, I thought that was enough to contact the elected state attorney at the time. His name was Brad King. And I sent him an email outlining all of these questions that were asked of the prospective jurors and the truth of the answers that had Rose answered truthfully, she would have disclosed these things, and she did not. I really thought that it was important. I thought that it was important that the state attorney's office know that there was a juror who lied their way onto a jury. I didn't get the response I was looking for. His office actually blocked my email address, so I couldn't send any future emails. And just days later, his assistant went into my sister's store and threatened me, told her that I needed to stop or I was going to get in a lot of trouble. Of course, my sister called me very upset, panicking, and asked me what I did. And I said, I don't know, other than try to expose the truth. I don't know why I would be in trouble. Well, the next month, I sent 30 pages of proof of Rose's lies to Judge Merritt and again expected outrage. I expected outrage. Why did I expect outrage? Because I will tell you why. Just a few months prior to that, An article had come out in the Tampa Bay Times entitled, "Hernando Judge Sternly Warns Residents Who Failed to Show Up for Jury Duty." And it's a picture of Judge Merritt holding out a flag. And I quote, "In a slow and deliberate voice, Monday, Circuit Judge Daniel B. Merritt Jr. read the names of Hernando County soldiers who had been killed in Iraq and Afghanistan. Silence filled the hearing room as Merritt recalled for the group of about 20 residents the sacrifice the soldiers had made for their country. He pushed back his chair, walked to the American flag hanging behind him, and lifted it. He said, 'Folks, get a good look. I mean, really.' Then he made the point of the afternoon's exercise abundantly clear. Quote, 'What I want you to do is show up for jury duty.' He looked down at those sitting in the audience and said, 'Act like an American. Act like you're a part of the community here in Hernando County.' For about an hour, Merritt gave a good old-fashioned tongue lashing to residents who had failed to show up for jury duty earlier this summer and nearly prevented the court from doing its job. For the week of June 23rd, the juror attendance rate was only 23%. The large number of absentees would have kept the 2 trials scheduled for the week from proceeding had the cases not been resolved at the last minute. Merritt cited this and other recent absences and decided to make an example. He recently issued orders to show cause for the jurors who failed to appear on June 23rd. The order required them to come in Monday to personally appear before Judge Merritt, with consequences ranging from a warning to a fine to potential jail time. The jurors got off this time with a stern warning and a promise that Merritt would be watching to see if they ever skipped again. Clerk of Court Don Barbie said this was the first time a Hernando judge had taken this type of action in at least a decade, though judges in other counties in the Tampa Bay area have done so. I might add that we were able to find another speech that was exactly word for word the one that Judge Merritt gave. Another judge had given prior. So he copied it. The prospective jurors filed in somberly into the courtroom before Monday's hearing. Merritt called their names. Of those successfully served with the order, only one person failed to appear. Merritt said he was considering issuing a warrant for his arrest. He went on to describe why they had been summoned. Quote, "Over the course of the last 5 or 6 months, there were several jury trial weeks which would have been lost because of a lack of jurors," he said. He told the jurors that this would have infringed on the constitutional rights of those involved in the trials. He said that's not something he takes lightly. Quote, "In my role as a public official, I would be derelict in my responsibilities if I did not address that issue with you." He had the group raise their right hand and swear to tell the truth. Initially, he indicated he would have those in attendance arraigned and that everyone would need to enter a plea. He then took a break. He returned and continued his lecture. Merritt said he had been thinking about what to do. He said Hernando is his home county where he has lived his life. Citizens failing to show up for jury duty, he said, makes him sad. Quote, "The more I think about it, the more it burns me up." He urged everyone to consider the importance of jury duty and to realize that there is something more to it than being inconvenienced. It's about the greater good, he said. He asked the group if they would be able to show up in the future. They all nodded and murmured yes. He said, "That is my fervent hope today, that perhaps some of you will get it. Some of you will have a new perspective about what your jury service means." So let me get this straight. If you ignore your jury summons, or you didn't get your jury summons, or you just forgot that it was jury day, and you don't show up for jury duty, you could be arrested and charged and fined and put in jail, according to Judge Merritt. However, when I exposed our jury foreperson and said she came into your courtroom, Judge Merritt, and lied to your face repeatedly about matters that were important, that would have gotten her struck had she been honest, because others did speak up and they were struck from the jury. He chose to do nothing. But it's even worse than that. The next month, I called Russell Cease. Russell Cease was, at that time, the investigator for the Hernando County State Attorney's Office. So I explained to Mr. Cease what I had uncovered about Rose, the same evidence that I had sent to Judge Merritt Jr. And I asked him if he was going to arrest her, charge her, investigate, speak to her about it, interview her, anything. Not only did he get mad at me, but he told me that he would not be able to do anything about Rose because it was beyond the statute of limitations, which was 3 years, he told me. 3 years. So because it had been 4 years, there was nothing he could do. I believed him. I didn't know anything about statutes of limitations or case law or anything like that. I shouldn't have, because that was a lie. Shortly after that, I began wondering, and so did Michael, why isn't anybody as upset about this as we are? This person showed up for jury duty, came in, gave a speech, obviously wanted on the jury, and now I know why, to exercise some sort of vigilante justice. So after explaining these things to Judge Merritt and to State Attorney Brad King and to the State Attorney's investigator, and getting nowhere other than they're mad at me now for exposing Rose and her lies, Michael and I began to wonder, what are we doing wrong? And why aren't they as outraged and horrified as we are? Because I felt like they should be. This woman committed a crime. And a man who is innocent is in prison for life with no chance of parole because she came into court and lied. So Michael actually had gone to law school with someone who was now a judge and arranged for me to go meet with this judge. I did. On a Monday morning, I showed up at his office, went into his chambers, sat across his desk, and I outlined all the things that we had found out about Rose. As I started to name all of these things, his face got redder and redder. He was clearly, visibly getting angry. And I said, Judge, I understand that this is not your courtroom. This is not your jurisdiction. I just need to know from your perspective as a judge, as an honorable court judge, if this had happened in your courtroom, what would you do? I can't say word for word what he said to me because it's been 10 years and I wasn't recording the interview. But he said, and I'll paraphrase, if that had been a juror that came in and lied to me, she would already be in handcuffs, arrested, and standing in front of me in my courtroom, answering for her crime. And I said, thank you, because that's what I thought should have happened, but it didn't. So a few months later, Martin and I put all of this together along with some other information, and we filed a pro se, which meant when you don't have an attorney involved, you file it pro se, meaning you file it yourself as a defendant. We filed a pro se motion alleging the juror misconduct and also ineffective assistance of trial counsel, where we outlined all the things that Martin's trial attorney failed to do during trial. Meanwhile, I kept digging, and so did Michael. While that sat on Judge Merritt's desk, it wasn't long before Michael called me and said, are you sitting down? Now, we had found a lot of crazy things and had been working at this, so I was already horrified by the things that Rose had lied about. And then I find out that her biological father, thanks to Michael's digging, was a convicted sex offender in Connecticut. A few months later, I was sitting in the home of my daughter and son-in-law. We had just finished supper, and my daughter, who is much more social media savvy than I ever will be, was looking on her phone, and she said, hey, Mom, you've got a message, a private message on your Facebook page. And I said, what? She said, yeah, and she started reading it. Someone had reached out saying that they were the current wife of one of Rose's ex-husbands and gave me her phone number and said, I need to speak to you as soon as possible. So I called the woman who'd left a message, and I told her who I was, and she said, listen, she said, I've read what you posted on Facebook about your case. And she said, I was absolutely horrified. She said, I know Colette. She said, Colette is my husband's ex-wife. And in fact, we are raising her son, who doesn't want anything to do with her anymore. She said she should never have been on anybody's jury. She began to disclose some things about Rose's troubled past. And I said, well, I need to know what you know. If you have any documentation that we can send to the court to show that she was psychologically unstable at any point in time, that would be helpful. I said, anything you can provide would be helpful. And she said, well, I'll do you one better than that. She said, not only are we going to provide you documents from their divorce, psychological profiles, I am going to call the judge and anybody else you give me names of, the prosecutor, Brad King, anybody you need me to call, and I will talk to them about Rose, aka Colette. So shortly after that phone call, I decided to call the Hernando County State Attorney Office's supervisor. His name was Conrad Juergensmeyer. He was quite pleasant at first, and we spoke for about 30 minutes. I kept saying that Rose had committed fraud on the court, and I again outlined all of the things that she had lied about during the voir dire. He listened, and then at one point he interrupted me and said, you're saying it all wrong. And again, I'm paraphrasing. And I said, what am I saying wrong? He said, you keep calling it fraud on the court. It's not fraud on the court. I said, all right, well, what should I be saying? He said, it's actually direct criminal contempt of court. Now he's saying that and I'm writing it down. I'm thinking to myself, wow, that sounds a lot more serious. I Googled it. Sure enough, I said, wow, that's a lot worse than fraud on the court. I appreciate you correcting me. And then I asked him if he was going to do anything, if his office was going to do anything about Rose and all the lies that she had told to the court and committed a crime. I said, I've just reported a crime to you. Are you going to do anything about it? He said, no. And I said, why not? He said, again, the statute of limitations has run out. It's been more than 3 years, so there's nothing I can do. When I protested, he hung up on me. Again, I believed him. I shouldn't have, because that was a lie. There is no statute of limitations in Florida on direct criminal contempt of court or lying to the court as a juror. It's considered new evidence and it can be raised at any time. And I know I sound like an attorney. I am not an attorney. I don't even would never want to be an attorney. I wouldn't want their job. But it was not true. The statute had not run out. They just chose not to do anything. Right after that, Rose's ex-husband and current wife were so frustrated by the fact that no one was listening nor would even return a phone call that they wrote a letter. They sent it to all the players. I'm going to read it. To whom it may concern, we saw an article on the internet that caused us great concern about a man in Hernando County, Florida, Martin Peterson, who is convicted of a sexual assault of a minor. We do not know Mr. Peterson, but we know the juror who was the jury foreperson. What concerns us is that Colette, aka Rose Elizabeth Stokes, was allowed to be on a jury of someone charged with sexual assault since her mother has law enforcement background, her family has been involved with fostering children, her father is a convicted sex offender and on the Connecticut Sexual Registry, and that she herself has in the past accused people of sexually assaulting her. With her past and background, we are shocked and appalled that she was even seated on his jury. People are supposed to be allowed a fair trial without bias. We do not know if Mr. Peterson is innocent or guilty, but we believe his trial was tainted. We believe he should be allowed a new trial for the above reasons. We had tried to speak with numerous people in different positions about our concerns, but no one seems to want to speak with us. They will not return our phone calls. If you require further information or have any questions, we would greatly appreciate you contacting us. Thank you for taking the time to read this. Sincerely. And they put their names and their cell phone numbers on there. Later, they sent me some of the information that they had found. Actually, they had been provided it by the former divorce attorney. Now, keep in mind that Judge Daniel Merritt Sr. was this man's divorce attorney. So for Rose to say she didn't know anyone in the courtroom seems that's a stretch. Keep in mind that on the top of the judge's desk is a big placard with his name. So I find it highly unlikely that Rose didn't recognize that name, but again, I'll give her that. We were provided some psychiatric documents. I'm not going to read all of them, or where they're from. I just want to give a few excerpts. Again, this is not meant to embarrass anyone, but I want you to get a feel for the level of concealment and deceit that took place by this person who ended up to be the foreperson of the jury, which might very well explain why the jury was only in that deliberation room for sheer minutes. Not even 30 went by before they were already out, had already decided, and Rose delivered the guilty verdict to the courtroom. This is one letter that was written to Rose's mother when she was younger, and the social worker said, "I strongly recommend taking Colette to a family therapist. The evaluation from here indicates she needs therapy as she shows signs of being depressed as well as behavior disorder." Another from the probation officer talked about her running away multiple times. This one was from an institute that was a psychiatric hospital, again talking about Colette's repeatedly running away, and said that she had to leave the Salvation Army due to sexually acting out. Her mother never got involved in the family counseling due to a lack of time. And then this also says that Colette made an allegation of sexual abuse about her foster father. She refused to go to a new foster home, again, ran away. So it's sad that she was a troubled teen, but it seems that she grew up and continued to keep this same psychological profile. Knowing now that Rose had falsely accused men in her past of sexually assaulting her, the question asked by the Assistant State Attorney Aaron Corcoran Daly became even more important. She asked the prospective jurors at the end of the voir dire, quote, "Anybody else who's known somebody who's been a victim of a sexual abuse in the past? I know I asked you earlier if you knew anybody who was a victim of a sexual assault, but has anybody ever known somebody who was accused of molesting or sexually abusing a child?" Again, Rose said nothing. Had she just spoke up to that one question, she would have been struck from the jury, but I suspect that she knew that. I'm going to conclude this segment by reading just the last paragraph of our supplemental motion that Martin and I put together. The defendant submits that Rose Stokes intentionally answered the voir dire questions in a manner that made her appear favorable to the defense, so she would be selected for the jury and could execute her own form of vigilante justice. Therefore, it is once again obvious from the facts set forth herein that the defendant was deprived of a fair and impartial trial, especially in light of the fact that Rose Stokes was also the jury foreperson. Therefore, the defendant again respectfully requests a new trial in this case, or at a minimum, an evidentiary hearing in which all parties are present to assert the truth of Rose E. Stokes' blatant concealment and consequent misconduct during his voir dire on May 16th, 2012. I still don't understand why no one wanted to talk to Rose. I wanted to talk to Rose. Everybody I knew wanted to talk to Rose. Why would you do that? Why would you come into court and lie about nearly every question asked? Why would you say you only had 3 children when you had 4? And why did you go to the courthouse just months before Martin's trial to be adopted by your grandmother? You're a grown woman on your third marriage. Again, you've got 4 children from high school to adult age. Why did you have your grandmother adopt you? Other than the fact that you used that opportunity to change your name from Colette Ann to Rose Elizabeth. I have questions. I guess they'll never get answered. Next week, we're going to talk more about what happened next. We're going to pick up from the motion that we filed, the supplement to the record that was granted, and how we got from there to Martin coming home just weeks later. Until then, if you know someone who is convicted by a jury and needs our help, you will find our contact information in the description below. So stay tuned for another episode of Jurors in Disguise. And remember, the courtroom may be silent, but we won't be. So speak up, speak out, and always speak the truth.